Well, welcome, and we're here to talk about immigration law, and let me introduce our speaker. Selena Britzius-Negash is an attorney and serves as the program director of the Immigrant Law Center of Minnesota. She's a 2003 graduate of Hamline University School of Law. She has practiced immigration law exclusively during her legal career. Prior to joining the Immigrant Law Center, Selena worked for several years at a nonprofit law office, Centro Legal, where she supervised the immigration law unit, and also practiced at the Minneapolis firm of the Wilson Law Group. She has significant experience in working to achieve immigration status for victims of domestic violence and other violent crime, and as well in representing individuals that are facing removal from the United States. In her current role at the Immigrant Law Center, she provides legal supervision, outreach, and education regarding a variety of immigration issues. Selena is one of the authorities in the state of Minnesota as it relates to immigration. Help me welcome Selena.
Thank you very much for the welcome, and I do appreciate the opportunity to be here to talk about immigration law with you all today. I would note that there are a lot of authorities in the state of Minnesota. We actually have a pretty good bar of attorneys locally who specialize in immigration law. Not to say that there aren't a few that maybe aren't so much authorities, but I am pleased to be here to be able to talk to you about immigration. I think it's a really interesting topic, not just because I practice immigration law, but I think it's becoming more and more relevant for everyone in our professional lives and the work that we do. I'm sure in the work that all of you do, you see it come up in various ways. In the work that you do, I think many of us know immigrants. We come from immigrant families, or we're married to immigrants, or what have you. So immigration law, I think at a certain point will intersect with your life. And it's good to have a little bit of background information. I will say that today's training is pretty heavy duty in the sense that it's a lot of information in a short time. I feel like it can be a little bit overwhelming, but it's really not for you to walk away feeling like you have a complete grasp on the law. It's really more to sort of give you an introduction to ways that people can get their legal status, how limited the forms for getting your legal status are, and then also to just help you maybe identify when someone's calling in that this may be a situation where immigration law is implicated, and this may be a person who warrants a referral to an immigration agency. So I welcome you to ask questions at any time. Don't have to wait until the end. Just interrupt if there's something not clear as we go along, because again, it can be quite detailed. My clicker's working today. I'm happy about that. It wasn't yesterday. So just a little bit about the organization that I work at. Immigrant Law Center of Minnesota we're located in St. Paul. We're a nonprofit law office. We serve the entire state. So we have clients across the state. We have our main office in St. Paul. We have a satellite office at the Neighborhood House, also in St. Paul, where our Karen-speaking legal assistant works. And then we also have a satellite office in Worthington, Minnesota, to serve the southwestern population there. We do direct legal representation to low-income immigrants. We use 187.5% of the federal poverty guidelines as our income level for case acceptance. Because the work that we do, we get funding and from charitable donations. So we really focus on the most low-income clients. In addition to providing direct representation, we do community education and outreach, as well as advocacy on immigration issues at the state and federal level. So right now our executive director he's everywhere talking about the possibility of comprehensive immigration reform, which we're really excited about and hope will happen. To start out with immigration law, I think just a very basic point to make is that immigration law is all about non-citizens. There are citizens of the United States, people who are born here or who become citizens, and they really won't be subject to the immigration law unless they want to file for a family member or something like that. Otherwise, immigration law is all about sort of controlling who is here who is not already a citizen. Just to define who is a citizen to begin. Citizens, of course, can be a citizen by birth, born in the USA. You know, if you're born here, our laws and our constitutions say that you will be a citizen by birth. You can also be a citizen if your parents are citizens and you happen to be born abroad. Young people under the age of 18 who are lawful permanent residents can get their citizenship automatically if their parent becomes a citizen before they turn 18. And then there's also a voluntary process of actually applying for citizenship called naturalization, where you fill out an application and you show that you're a fit candidate to be a citizen of the United States. Non-citizens can really run the gamut. You can have people who are here undocumented, people who maybe entered with a visa but are now out of status because they overstayed their visa. They can be undocumented because they crossed the border without inspection or without presenting any visa. Basically, they crossed the border illegally. Then there are non-immigrants. Those are people who come intending just to visit, maybe with a student visa or a visitor visa. And that's a temporary status that ends at a certain point, and then they're supposed to return home after that. And then, of course, there are immigrants. And an immigrant really is defined by someone who intends to remain in the United States and make their life here. And we know them usually as lawful permanent residents or people who have a green card. So I'm going to talk about some of the ways that people can get their legal status in the United States. There are just myriad little bits of the law that I will go into as well, but there are three sort of primary categories. And the first one is through family, and that would be where someone is filing a petition to request that their family member be able to either come to the United States and have lawful status, or if that family member is here, that family member can remain in the United States and get their lawful status. The second main category is just generally titled freedom. By that we mean people who are fleeing their homeland and seeking freedom in the United States, seeking refuge in the United States. So that would be refugees or asylees. And then there's employment-based immigration. And I have to admit right up front that I do not specialize in immigration law or in employment-based immigration law at all. It's a totally different animal. The clients of immigration law attorneys who practice employment immigration law are, typically companies who are hiring foreign nationals to come here and work. And having worked mainly in nonprofit, that's just not a clientele that we've ever had. So we focus on families and individuals. And the law is very vast too, so there's a lot to it. There's plenty to learn without introducing employment. To go into a little bit of detail about refugees and asylees, first of all, I just was wondering, do people have ideas about the refugee groups we have in Minnesota? Any ideas? We're like the top state for a couple of different refugee groups. Anybody have ideas?
Of who they are?
Yeah, what countries or?
Asian countries and South African countries.
Mm-hmm. We have, I think, if I'm not misquoting this, either the top or the second highest population of Hmong refugees. And then I think we're the number one in the country for Somali refugees. We also have a growing population of Karen refugees. It's an ethnic minority from Burma. And that population is growing more and more in our state as well. So Minnesota, compared to other states, has a pretty sizable population of refugees. And a refugee is basically someone who has fled their homeland because of persecution based on their race, their religion, their membership in a particular social group, or race, religion, national origin, social group, or their political opinion. So we see people who've had to flee their homelands and live in refugee camps, and then they come and get resettled in the United States. So a refugee is someone who's classified before they come into the United States. They're given that permission to enter here abroad before they come here. Whereas an asylum seeker is someone who comes to the U.S. and then requests the protection of the U.S. So someone who maybe comes on a student visa, and then that's sort of their entry into the country, and then they claim the protection of this country because they're being persecuted in their homeland. There's a whole bunch of sort of special provisions that I'm going to get into later in the presentation that I think are quite relevant for the work that you do, or I'm guessing it is, for the types of calls that you might get. So I'll get into these a little bit later. Another sort of temporary basis for being here legally is something called temporary protected status. And I don't know if people have heard of people who have TPS, but TPS is basically a temporary status for people who of certain countries who are here, and they may have come in illegally even, but the government is now saying, we're not going to force you to return to your homeland because your homeland really isn't prepared to receive you back right now. Maybe there's been a natural disaster, a hurricane or earthquake that's ruined the infrastructure of the country, or maybe there's civil strife going on and the country really isn't prepared to receive its nationals back. These are the countries that are currently designated for temporary protected status. The main clients that we see at our office are nationals of El Salvador and Honduras, and they're able to get a work permit and work lawfully for a period of usually 1.5 years, and then they renew that status. So there are quite a few people from these countries who have this status.
Selena, how often do they update those countries?
It just depends on what's going on. There was like an eruption of a volcano in Guatemala like 1.5 years ago, and it was really terrible. Like, I think people got killed and it ruined villages and stuff like that. And we were really hoping that the government would designate Guatemala as a TPS country, and it didn't. So it just depends on what's going on in the countries. I think every year they evaluate and see, is this country is it in a position to take its nationals back? Liberia is an example of that. Liberia had TPS for many years, and then at a certain point, I think it was under the Bush administration, they ended it because they deemed that the country was no longer undergoing the civil strife that made it hard to go back there. However, the government has now given Liberians something called deferred enforced departure. Basically, you no longer have TPS, but we're still not going to deport you, and we're still going to give you a work permit. So it really depends on the conditions on the ground in those countries.
Thanks.
And like Syria is a new addition,
right,
because of what's happening there. All right, family. Family is a major basis for immigration. Does anybody know anyone who, married someone from another country and is going through the immigration process, or heard about that? Not too uncommon, right? And have you heard about how challenging it's been for them? Yes, it really is. I mean, depending on the situation, it can be very challenging for people, even if they're married to a U.S. citizen, to get their status in this country. So who do you all think can file a petition on behalf of family members? Like, what do you have to be?
Immediate family.
So the person you apply for has to be an immediate family member, right? And even to file a petition, you yourself have to at least be a permanent resident or a citizen. So the law really only recognizes this family reunification if you already have the requisite legal status to be living in this country. Seems logical, I guess. U.S. citizens and permanent residents can file for certain family members, and citizens, not surprisingly, have more advantages under the law than permanent residents do. A citizen can petition for a longer list of individuals, as you can see here. They can petition for a spouse, parent, an unmarried child, as well as a married child, and siblings as well. Whereas permanent residents can't file for their parents or their siblings, and if they file for their children have to be single. So citizens really have a lot more rights under the law, and the process is also quicker for their relatives. So if a U.S. citizen wants to file for his or her spouse, after they file that petition to show they have a bona fide marriage, then that spouse can apply for their permanent residence right away. They don't have to wait once that petition is approved. Whereas a permanent resident who files a petition for his spouse, that spouse is going to be waiting between 3 and 6 years before she's going to be able to even apply for her visa to come into the country. We're hoping that's going to change if there's any comprehensive immigration reform, because we see families separated just for too long. And then just everything else varies. A sibling of a U.S. citizen right now is, if you're from Mexico and you file a petition for your sibling, that sibling has at least a 15-year waiting period before they can apply to enter the country legally. So these are the backlogs that they talk about when they're talking about immigration reform and why people need to go to the back of the line. This is the line. It's basically, there's something called the visa bulletin that controls who can apply and when, based on when their first petition was filed. It all gets pretty technical.
Selena,
Yeah.
do they no longer have the visas where if you're engaged for someone from another country, you have to come into this country, but you have to be married within a certain amount of months after entering?
I don't think we have that in our PowerPoint, so thank you. Yeah, that's a fiancé visa. Yep, that still exists. So yeah, that's another way, is you don't necessarily have to be married. If you're a U.S. citizen, you can file for a fiancé abroad, bring them over, get married, and then they file for their residence.
Okay.
So that's another way. Yeah, another advantage that we should actually add to our list of the people that citizens can apply for, fiancés. So after you file the petition, as I was explaining, there needs to actually be a visa available for that person, and people will wait, in some instances, many years for their time to come. And it's no wonder that many people end up just crossing the border illegally if they're from a country where it's easier to do that, because it's just hard to be separated that long. And where you apply for your visa will depend on some factors. If you're living abroad, then you will go to the U.S. Embassy or consulate in your home country and present yourself to be interviewed to get your visa there. If you're living in the United States and you qualify to apply here, then you would go to your immigration interview just, 4 blocks from here at the immigration offices over on Metro Boulevard. So, and then there are people who are here in this country but don't qualify to apply directly here with immigration. They have to actually go home to their home country because they lived here without authorization. So that's where the process can become difficult, because when they leave, they become subject to a bar. They need to file a waiver to pardon that time they were here illegally. And this is why it becomes very challenging for people. Every time someone thinks, well, I'm married to a citizen, I'm just going to get my green card, I want to caution them and say, wait, you really need to talk this through very thoroughly with an experienced immigration attorney to see how the process is going to go for you, because you can really kind of mess up your case and end up being stuck outside the country in some instances if you don't know the proper route to go. So we always urge caution there. And before people get their permanent residence, the government will evaluate them thoroughly to see if they're a good candidate to live in this country. So of course they're going to undergo background checks, and they're going to have to reveal all of their immigration history if they've come into the country illegally before or ever committed any fraud. And if they've done certain things, they could be deemed inadmissible or ineligible for their permanent residence. And one of the examples that I cite, because I still think it's shocking, even though this has been a law on the books for 15 years, is that if you falsely claim to be a U.S. citizen, you will never be able to legalize your status. So even if you're married to a U.S. citizen and you're here and you're trying to support your family and you go and you apply for a job, but because you don't have papers, you mark that you're a citizen on the I-9 form, that can really render you ineligible forever under the current law from getting your residence. So the law is very harsh in some instances. This is a sample of a work permit. This is a document that people get so that they can show that they're authorized to work in the United States. This is what someone that, for example, with TPS would have, temporary protected status. It just shows, it has their photo and fingerprint and everything, and it's an indicator that they're authorized to work in the U.S. This is the new green card, permanent resident card. And it started out being pink. I don't know if it was ever green. I don't know why it must have been green way back in the day. I don't know. The oldest ones I've seen were pink, and then they were white, and then now we've got a little band of green up there. So now that we've talked about some of the temporary statuses and then lawful permanent residence, the next sort of ultimate stage of immigration is naturalization. It's really the best form of immigration status you can have. And you can only apply for naturalization once you've had your green card for at least 5 years, unless you're married to a U.S. citizen, in which case you only need to wait 3 years. And it's a voluntary process. People don't have to apply to become a citizen if they don't want to. They can continue living in the U.S. with their green card indefinitely until they die if they would like. But there are very many advantages to becoming a citizen. You can never be deported. That's the hugest advantage from my perspective. Your children who are under 18 and who also have their lawful permanent residence can derive citizenship automatically once you become a citizen. As we know, you can apply for more family members if you're a citizen. You're eligible for more forms of public benefits as a citizen. You can travel as long as you want without worrying about coming back into the country, because permanent residents can't travel for too long, or immigration could think that they've abandoned their status. So more than 6 months out of the country, and immigration might really question a permanent resident about their intention to remain in the U.S. So for people who like to travel a lot, we say you better become a citizen. And of course, you get to vote if you're a citizen and really participate in the highest form in our civic process. There are some disadvantages or hurdles to becoming a citizen. You may lose some rights in your home country, but by becoming a citizen of the U.S., maybe you won't be able to hold public office there if you were planning to do that, or own property, other things like that. Some people have difficulty establishing good moral character. You need to show that for the last 5 years you haven't had really anything more than just tickets or minor infractions under the law. One thing that's difficult for a lot of people is that there's a test on English and U.S. history and government. So, and also the whole interview has to be in English. And a lot of people have difficulty with that. They may have lived in this country for well more than the requisite 5 years, but they've never really had to learn English because they've worked with other immigrants and spoken their own language, or they really didn't leave the home very much. So that can be a problem for a lot of applicants. There are exceptions that can apply if you have a mental disorder or medical disability that makes you unable to learn English or new things like civics. So, but in those instances, you'd need to have a medical certification proving that. And the other risk of applying for naturalization is that you're making yourself vulnerable to immigration again. You may have been floating along as a permanent resident for many years without immigration paying any attention to you or knowing about you. But once you apply for citizenship, you're going to be undergoing one last very deep background check before they're going to give you that citizenship. So there are people who don't realize that conviction in their past makes them vulnerable to deportation. They may not know. They may just think it's a minor thing. Maybe they have a conviction for violating an order for protection. That's only a misdemeanor. They may not think that's any big deal, and yet it's a deportable offense. So when we have people applying for citizenship, we really screen them really carefully and caution them against taking the whole process too lightly, because the worst thing is just going forward, not knowing the risks, and then suddenly finding yourself in deportation proceedings. This is an example of the naturalization certificate. It's missing the photo, but that's what they look like. Now to the downside, removal or deportation. So this would be people who aren't citizens. These are going to be the people who have to think about this. So removal, as you probably know, or deportation, is being forcibly expelled from the United States and sent back to your home country. And the people that can be deported really are almost everyone who's not a citizen. Undocumented people, obviously. Someone who came in legally, but now they've overstayed. If ICE catches up with someone who's overstayed their student visa or stopped going to school, they're now subject to removal from the United States. And even, as we just talked about, green card holders, legal permanent residents can be deported if they've committed certain offenses or have other violations of the immigration law. And, you know, the law really doesn't care even how long people have lived in the United States. Immigration judges, when they're reviewing someone's deportation case, they do not have the discretion, the law does not give them any discretion to give a reprieve to someone who has lived here since they were 1 year old. And that's very common to have people who have been here almost their whole lives and yet have lived here undocumented their whole life. But the law doesn't provide any way, just from having been here your whole life, to remain here. Even if you don't know the language of your home country, or if there's no one there to receive you, no family, you can still be deported.
What about the DREAM Act? How does that change that?
Deferred action for childhood arrivals? Yep, I'm going to get into that, but that's a great point. I mean, that's a new form of relief that we've really welcomed because it's helped a lot of people. Yeah, so it's just coming up along in the presentation, but great point. So this can just give you an idea of how relevant deportation has become in the country. It's really increased just exponentially in the last decade. And we've seen that just on an anecdotal basis locally in our work. More and more people, not only more and more people in removal proceedings, I mean, the immigration courts are overwhelmed. Their dockets are just huge. ICE, the enforcement arm of immigration, got lots of funding to go out and apprehend people and initiate removal proceedings, but that same level of funding was not given to the courts. So they're struggling to keep up with the number of removals. And then not only are more and more people getting put into removal proceedings, but they're also being detained when they weren't before. In the past, you know, if you were apprehended by ICE and found to be undocumented or out of status, they would say, okay, you're in removal proceedings now, and I'm going to send you a notice of your court hearing, and you have to show up because you're in removal proceedings and you're probably going to get deported. Now they don't give people the option to do that. Now, typically what's done is ICE detains that individual and requires a $10,000 bond for them, at least, that's sort of the starting point nowadays, for them to get out of custody and be free while they're trying to fight their deportation case. And that's really hard for a lot of families, as you can imagine, because it's not a percentage like it would be in a criminal bond. It's the full $10,000 that they have to pay. And then there's no right to government appointed counsel in removal proceedings in immigration court. Like, you know, there are public defenders in the criminal sphere. We don't have that in immigration law. So you have a lot of people who don't get help. In the materials, we've mentioned something called the Minnesota Detention Project, and this may be something that's relevant to tell people who call in. Our office is one of the partners in this collaboration. Basically, it's a group of some of the nonprofits in town, our office, and the Advocates for Human Rights, as well as law schools, local law schools that have immigration clinics where they're teaching students about immigration law. Through our collaboration, we ensure that there is a volunteer attorney there at the first hearing for everyone who's detained and doesn't have a lawyer. So anyone who's detained is unrepresented will have the opportunity to talk to a lawyer or to a supervised law student to evaluate their case before they go in and see the judge and see if there's any defense that they're going to have in their case to be able to fight their case.
And Selena, if there is a defense, then do they work out some kind of representation for that person?
Sometimes. If we have the capacity, then whoever has done that intake on that person will try to refer it to one of the offices, usually our office, Immigrant Law Center, to see if we can help out that individual, and sometimes we have capacity to do that. And if not, then what we try to do is at least give them a list of private immigration attorneys that we know are experienced and reputable so that they can pursue the relief on their own. But if there's a really vulnerable case where the person is just clearly not going to be able to hire an attorney, we try to, when we can, step in and take on the full representation of that person.
Are there interpreters with them at that first trial, or?
Good question. There's always a Spanish language interpreter in the court. And for other languages, if they need an interpreter, they'll get someone on the language line.
Okay.
So
even with the legal consultation?
Oh, I see. Well, all of the staff of our office speak Spanish, and that's the main language we see down there. But once in a while, we'll get another language. And if we just are unable to communicate with that person, we'll tell the judge when we go into the court with them so that they can get someone on the language line in there. And then, it's challenging. But most of the time, I would say the non-Hispanic clients speak enough English to communicate with a volunteer attorney. And if the volunteer attorney who's there doesn't speak Spanish, then they arrange to have a volunteer interpreter come. So usually the language needs are accounted for.
Okay.
Yeah, good question. Some of the forms of relief from against deportation are, anything under the law that the person might otherwise qualify for. One of the main ones that's specific to just being in deportation proceedings is something called cancellation of removal. And this is something for people who have been in the U.S. for at least 10 years. So this is one where they take into account your years of residency in the U.S. But on top of just having been here 10 years, you need to show that you either have a child, a spouse, or a parent who's either a citizen or a resident, and that person is going to suffer exceptional and extremely unusual hardship if you're deported. So it's sort of this three-tiered requirement to be able to cancel your removal. Not only at least 10 years and good moral character, but also that your family member, and only your family member with citizenship or permanent residence, has some severe health issue or maybe, very severe depression, debilitating depression or something like that. Only in those instances will that person be able to cancel their removal. But the person might also qualify for asylum, or maybe they have a family petition that's finally come current under the law and they can apply for their residence that way. A couple of times we found people who were automatically citizens and didn't know it. And that's just like finding a needle in a haystack, and you're so happy when you're able to tell ICE, release this man, he's a citizen. His parents got their citizenship before he turned 18, so even though he's got a removable offense, he can't be deported, he's a citizen. So there are sometimes things we can find. Sadly, there's a lot of times when there's just absolutely nothing that the person qualifies for, and they have to either just request to leave voluntarily by paying for their own ticket, but they never get out of custody if they're detained, or just accepting straight up deportation. So it's pretty demoralizing down there at detain court sometimes. And deportation can apply equally to children. I think sometimes people are shocked to think of a small child being subject to ICE wanting to deport them, but under the law, they are equally susceptible to deportation. Children who are U.S. citizens, again, won't necessarily be an anchor or a prevention from their parent being deported, unless the parent has all of those other elements for something like cancellation of removal. So sometimes a child will go on the deportation flight with the parent. We can arrange for that with ICE. Some parents arrange for their children to remain in the U.S. with family members. The government agencies that are involved in immigration, there are several. The Department of Homeland Security is sort of the umbrella agency that was created after 9/11. And under that agency, you have U.S. Citizenship and Immigration Services. That's the office that receives your application for your green card and interviews you on it. They have their offices just right over here on Metro Drive. U.S. Customs and Border Protection are the officers at the airport when you come into the U.S. that inspect your visa, or they're also the Border Patrol. There's U.S. Customs and Immigration and Customs Enforcement, ICE. We think it's a really fitting moniker for them. They're also located in the same building as immigration. They're in charge of arresting and detaining people, processing them for removal. And then the immigration courts, that's the judges who decide immigration or deportation cases, and the Board of Immigration Appeals, they fall under the Department of Justice. And then there's the Department of State, which is in charge of processing visas and also participates in processing refugees from abroad, in addition to many other government agencies. Now I'm going to get into some of the special provisions for vulnerable populations. And I think that this, I heard yesterday after the talk from one of your colleagues that this was the part that was maybe most helpful or surprising of all of the information. And it may be because these are some of the situations that might come in over the phone for you. And I'd be curious if we have time at the end to hear if you have had calls like this, or if you've been confused or wondered if immigration law was implicated in someone's situation. So I'll go into these in a little bit more detail. VAWA is the Violence Against Women Act. This is a law that was created by Congress when they recognized that there were citizens and permanent residents who were bringing their spouses into this country or marrying them here, and then not following through and applying for their legal status for them and not petitioning for them. And that this was usually out of sort of a cycle of abuse and control, where as part of the domestic violence in the relationship, they were keeping them in the home, keeping them undocumented, keeping them under the threat of deportation. And Congress recognized that this was preventing these women from reaching out and requesting help when they needed it, from calling police, from even going to, a domestic violence advocacy organization, because they're so isolated and afraid that if they leave the home, immigration is going to pick them up. And that's a really common threat that we hear from clients that their husbands have told them. And it's not only women who are victims. We've had many men who have been in the same situation. So this law, the VAWA law, takes away the power of the abusive spouse by allowing the victim to apply for her own legal status. She can file what's called a self-petition if she can show that her abuser is either a spouse, parent, or a child who is a U.S. citizen or a permanent resident. And if it's their spouse that's abusing them, they need to show that it's a legitimate marriage. And they need to have some kind of evidence that they were the subject of battery or extreme cruelty in the marriage. So that might be a really detailed affidavit. It may be an order for protection. It may be letters from friends who've witnessed the abuse or neighbors who've heard the abuse. It can be just a variety of evidence to help show the abuse in the relationship. And she would also need to show that she has good moral character. If that petition is approved, then that person can then eventually apply for their lawful permanent resident status as well. So it's a really excellent law, without which we would have a lot of victims who should otherwise have legal status, afraid, living in the shadows, being afraid to end that cycle of abuse.
Do they have to have entered that country legally?
No, they can have entered illegally and still qualify.
Okay.
Yep, good question. Mm-hmm. Oops.
So if you,
Yeah.
there are all kinds of factors that go into it, obviously.
Mm-hmm.
So that's thanks.
Oh, yeah. Yeah, lots. I mean, it's there are a lot of factors that go into a VAWA case. And I'm wondering, has anybody heard of that before? Anybody heard of VAWA before? Yeah? Mm-hmm.
Yep.
I think it's something that people, especially the victims, are surprised to learn exists because they're living in fear. And once they're told, well, we can apply for you, we don't have to involve your husband at all. He doesn't even have to know that you're doing this. And he'll be surprised later when you get your legal status and, you can leave him, you can work, you can be independent of him. U visas. U visas, anybody heard of that? All right, yes. U visas have been sort of the growth area of immigration law for the last 5 years for immigration attorneys, and I think the immigrant community in general is more and more aware of it all of the time. There's a lot of outreach, that's done on the radio, church presentations, stuff like that. Our office talks to law enforcement quite a bit also about the U visa. The U visa is somewhat similar to VAWA in the sense that it's meant to protect victims, particularly victims of domestic violence. But it's also meant to encourage people to report crime generally and to not be afraid to contact police. We know that a lot of immigrants, because of their undocumented status, are afraid to call 911, to report a crime when the police does show up, because they're afraid that they're going to be taken away and reported to ICE because they're afraid it's going to come out that they're undocumented. And again, a lot of times the abuser has just ingrained this notion in their mind that that's what's going to happen, and that their children are going to be taken away, or that even he, the abuser, is going to be taken away. Sometimes that's actually accurate. He will be taken away. But the rest of it isn't. So it was really, this law was passed really to encourage victims to cooperate with law enforcement without fear about their immigration status. And it's also to give humanitarian relief to crime victims and their derivative family members. The first requirement is that you have to have been a victim of a qualifying crime. And this is the long list of qualifying crimes. You can see it's very, serious, violent crimes mostly that are included here. The ones that we see most often at our office are domestic violence, which can include a violation of an order for protection, and as well as just straight up domestic assault and sexual assault. The other big one we see is felonious assault, basically felony level assault. And quite often the victims we see are people who have been robbed at gunpoint, severely injured in an assault or a robbery. Basically, if these victims have cooperated with police in their investigation, or if the case was prosecuted, if they testified or if they gave information to the prosecutors, then they can potentially qualify for a U visa. But they need to show that they've suffered substantial harm, and that's why the list of crimes is a list of pretty serious crimes. You see that there's no property crimes on there. No sort of simple mugging will count. There needs to have been a serious injury that results. If not physical injury, then emotional injury. And with the emotional injury, they really recognize that domestic assault, even if the battery isn't severe, the psychological impact is quite severe in many instances. So they have to show the substantial harm. They have to show that they have information about the crime. If the victim was a child and they're unable to sort of give the report, then someone else can give the report on their behalf, and that child can still qualify. And again, they need to show that they either were helpful, are being helpful, or are going to be helpful in the future. So there's no statute of limitations on when the crime even occurred, because the law says they will even count people who were helpful in the past. I had a client who was a victim of attempted murder in 1994, and we got the case approved. So you can go back quite a ways, which I think amazes people, because the incentive for reporting the crime is gone. They already reported it a long time ago, and yet the law recognizes also that some humanitarian relief might be in order for that person. The crime has to have occurred in the United States, so it has to have occurred here and been investigated or prosecuted here. One thing that's not on your handout, but that I added because I'd never want to forget this, is that the applicant can be a direct victim or an indirect victim. And an indirect victim might be, for example, a mother whose child was a victim of sexual abuse. The mother reports the crime to police. She's the one giving the information and helping with the prosecution, perhaps. And she's also suffering that substantial mental harm. That's a requirement of the law. So in this case, even if her child is a U.S. citizen and doesn't need the U visa herself, then the mom can apply as an indirect victim. And this is sadly a case scenario that we see too often. But it's something of a relief for these mothers to know that they're going to be able to get status and be here to help their child as their child lives. Their child's a U.S. citizen and is going to live here for their whole life. They want to be here and not, be afraid to be here and not be afraid that they're going to be separated from their child. So it's a really good way to use the law to help people. The primary requirement before we can file any application to immigration is something called a law enforcement certification. This is basically a form that we send to Minneapolis police, where we say our client was a victim of domestic assault on this date. As you can see from the attached police report, she was cooperative in the investigation. She gave you information about the assault. We believe she's eligible for a U visa. Will you please sign the certification attesting to her cooperation? If we get that signature on the certification, then that's the primary requirement for the application, and we can build the rest of the application after that. The thing we run into is that not every law enforcement agency wants to help out with that, and they're not obligated to under the law. The federal law says they should, but there's no obligation, and we see that simply there are some police departments that feel that they don't want to have anything to do with illegals. So we're really sad for our clients in those cases because they won't be able to apply for the U visa. The benefits are really excellent. If your case is approved, and right now it's taking about a year for the application to be processed, but if your case is approved, you can get legal status for 4 years, and you get a work permit with that legal status. And then after 3 years, you can apply for your permanent residence or your green card. And you can also include children, minor children in your application, spouses. If the victim was under 21, they can include their younger siblings or their parents as well as derivatives. So we've been really able to help a lot of families under this law. Victims who are partially culpable for the criminal activity obviously wouldn't be eligible. So if there's a mom who is making her child vulnerable to sexual abuse by her partner or something like that, she wouldn't be a good candidate for the U visa. Also,
Did you say that, I'm sorry, I just saw on that one screen, so they can't apply for any federal public benefits? Okay.
Right.
Okay.
Right. And a lot of times people qualify for benefits through their children are eligible to get benefits because their children are citizens. So a child might get MFIP coverage, something like that.
Okay.
But most immigration statuses, in fact, just generally, it's very hard to get public assistance.
Okay.
Even if you're a green card holder.
All right.
Medical assistance and all that. It's hard. The distinctions between the U visa and the VAWA are that with a U visa, you need a law enforcement investigation or prosecution, whereas you don't need that with VAWA. With VAWA, the abuse needs to have happened from a certain family member, a spouse, a parent, or a child, and that family member needs to have citizenship or lawful permanent residence.
So you couldn't use like court documents in place of the law enforcement?
In the case of a U visa?
Yeah.
Yeah, yes, because a court document would usually suggest it had been prosecuted. So in that case, yes. What kind of court documents do you mean, like?
Just the court documents that show that the person had came in and testified, or
Yep,
that
exactly.
or the the evidence that says this is where we got our information from, whatever.
Yeah, exactly. If you have
The way you're wording it, it seems like if they don't sign off on it, then we don't. Then
No,
they don't.
that's-
get involved.
Well, that's true. So for the U visa, law enforcement has to have become involved, either police or some other body such as the Department of Labor or Child Protection or something like that.
Okay, I was just wondering, because you made the statement that if they don't sign on it,
Yep.
Then.
Right, so the first step is law enforcement has to have been involved, and then also they need to sign off on the certification. So like in a VAWA case, you can have domestic violence that's happening, but the person never reports it to police, and that's okay. But with a U visa, if there was never any report to police, such that we could ask police to sign off that the person cooperated in their investigation, then we don't have a U visa case.
What if
Did I clarify that?
Well,
No?
what if the police are say they're racist and they don't want to sign off on it? Is there another way that they can prove that they are cooperative? Like
Like I said, with
the
court
court
documents.
Oh, I see what you're saying. Oh, I get it now. Okay, sorry, a little slow on the uptake there. Okay, so maybe the police won't certify, but this
Right.
person also helped with the prosecution.
Right.
Yes, we approached the prosecutor's office in that case, and usually if the case was prosecuted, we just go straight to the prosecutor anyway.
Okay.
Yeah, no, good question. Sometimes we have the option to pick between police and prosecutor. Sometimes, and I would say the majority of the cases though are never prosecuted. The offender is gone on arrival, maybe he's been deported, or maybe they just choose not to prosecute it. So in that case, we can't go to the prosecutor. And we only have the police as an option. But
Why wouldn't you be able to use the prosecutor's office, considering they're the ones who make the decision on if they prosecute or not? Wouldn't they still have the paperwork that says, you know, Jane Doe came and
yeah,
reported this and,
but then they didn't need much, they didn't need any further input from the victim in that case. I have tried that. Believe me, I have, when the police has refused, because, you know, that's just it. They then sometimes send the case to the prosecutor's office, but sometimes they don't even do that.
Marion, I think that what your question helps implicate really is that when it relates to people who are illegal in the country here, there are a lot of different layers that go on, and many of those layers are tinged with racism or with you know, just attitudes about, you know, us versus them and those types of things. And so sometimes you can have the letter of the law, you can have the spirit of the law, and then you can have the attitude of the law.
The other law.
Yeah.
Yeah.
So,
I
I think you're very astute to be asking.
No,
this
that's
question.
I'm glad you clarified that, because that's true. I mean, if we don't get it from one, you know, agency, we will certainly try whoever else was involved in it. And sometimes we run up against neither party wants to certify, because it's just part of the general law enforcement culture of the region there. And those are really sad cases. I won't name names, but there's a couple of towns and counties that we've had trouble with, just because of an overriding anti-immigrant sentiment. And in those instances, all we can really do is try to educate them a little bit more. I think it helps when we can tell law enforcement, like, look, all you're doing is saying that the victim gave you information and helped in the investigation or the prosecution of the crime. You're not the one giving her a visa. You're not the one giving her a green card. She's going to have to undergo a background check. She's going to have to show that she suffered substantial harm as a result of this crime. And that's all a decision for immigration. That's not going to be on law enforcement. I think they worry that they're giving a carte blanche to someone, and they don't want to become involved in immigration. So that's often, if we can educate them about that, then they're sort of like, oh, all right, that's not so bad. Then we'll sign off on this. And it really, in the end, it helps their community policing, because then people are more willing to reach out to them, and they can apprehend more criminals, and they can investigate more. So that's the intention of the law, and hopefully it works.
On the one on the U visa, it says limited to 10,000
Yeah.
annually. So is that
Yeah.
something where, like, at the beginning of the year they're just gone, and then the rest of the year there's no chance for you to get one, or how does that work?
Yeah, it usually takes almost a whole year for them to go through them, or maybe more like 9 months.
Okay.
And the fiscal year starts in October every year, so that's when they open up a new allotment of 10,000. So if someone didn't get approved in this year, chances are then as soon as the new year opens, then they'll be one of the first to get one of the 10,000. And people, I mean, the processing is taking about a year right now, but no one is ever sort of like cut out because the 10,000 cap was up.
Okay.
Good question. Did I miss anything else there? Okay. No.
And Selena, you've got about 15 more minutes.
Okay, I think we'll
great.
make it.
Yep,
All right.
thanks.
So the T visa is kind of like the U visa, except the victim in question is a victim of a severe form of human trafficking, usually sex trafficking or labor trafficking. And in this case, they only give $5,000 per year. So sex trafficking would be like, people brought into the country to work in prostitution rings without any chance of ever getting out of it. They're probably not even being paid. They're basically being imprisoned and controlled. In labor trafficking, we see people brought into the country. I mean, it can be any type of different instances. I think there was a case recently locally of people brought in to work as subcontractors in poultry processing, just working under horrid conditions, housed in these trailers in cramped conditions, not being paid their full wages, and really not being allowed to even leave the premises. So that might be another instance. Also, domestic servants who are brought into the country and basically kept in indentured servitude in the home of their employer. Those are examples of trafficking where the victim, through force, fraud, or coercion, came into the country and now is stuck here. You have to be physically present in the U.S. to qualify for the T visa, and you also have to comply with any requests from law enforcement as they investigate the crime. And you also have to show that if you're returned to your home country, you're going to suffer some extreme hardship or unusual harm. And that may be like punishment from your traffickers or who are going to seek you out in your home country. Juveniles. So I think I'll just kind of go over this part quickly, but we see a lot of young people, youths, ages 13, 14, who are traveling to this country on their own, fleeing problems in their homeland. Maybe they've been abandoned by their parents. Maybe their parents are here and they're trying to reunite with their parents. Maybe they're fleeing gang recruitment in their home country. So they are smuggled into the country, and oftentimes we see them being caught at the border, and then they're in removal proceedings, and we try to see what we can do to help them. These are some of the ways that maybe they could qualify for a status. Again, a U visa if something's happened to them here, maybe VAWA if they have a family member abusing them, TPS if they came on time to qualify for TPS and they're from one of the TPS countries. Asylum, I think, is a big one right now for a lot of youth from Central America who are being threatened that if they don't join these criminal gangs, they're going to be killed. Those cases don't work very well. They're not really recognized right now under immigration law, unfortunately. And then I'm going to get into the deferred action for childhood arrivals, which you mentioned earlier. And another big one is special immigrant juvenile status. And this may be something that the law is somewhat complex on this, but your antenna may be raised if you have someone calling and who's saying, I'm calling because, there's this young man who plays on my son's soccer team and he doesn't seem to have any parents and he's from another country and I don't know what to do with him. And, I don't think he has any papers, but I don't know, and I don't know if I should bring him to the authorities or whatever. We actually had a client like this of a young man coming to try to find his dad. His dad wanted nothing to do with him. He was sleeping in a park, in southwestern Minnesota. When this mom took him in and she got guardianship of him through the court system. And once she got into that court system, this child became eligible for special immigrant juvenile status because they were able to get a court order saying that it's not in the best interest for this young man to go back to his home country, and he's been abandoned by his parents. So it's in the best interest that he remain here. When we have that type of situation where we have a court order from a juvenile or family judge saying these things, then we're able to go in on the immigration side and apply for legal status for them through the special immigrant juvenile status. It's quite complex. And our office, when we work on these cases, we always need a partner on the family court side to do that other portion of the case, because we don't do that part of it. But it's something that works for young people here who have been abandoned or abused or neglected. I think I already covered that. Okay, DACA, Deferred Action for Childhood Arrivals. This is what people have come to know as DREAMer. The DREAM Act was proposed, is up in Congress, I don't even remember when that was, a few years ago, and it didn't pass. Basically, the DREAM Act would have given lawful permanent resident status to young people who came here, brought here as children by their parents. They're here through no fault of their own, and they're in school, they've graduated from high school, they're in college, they want to go into the military, they really want to contribute and continue living in their home country that they consider home, but there's no legal status available to them. They can't get driver's licenses if they're undocumented. So Congress tried to get this legal status, especially for them. It didn't pass. And so last June, President Obama announced something called Deferred Action for Childhood Arrivals. Did anybody hear about that? June 15th of last year? It was really big news in our office. It was just like, the hotlines were lighting up. We were just all really excited. We haven't seen anything like that in quite some time. So basically what this policy said is that, you know, if you came into the U.S. Before the age, here we go. If you came into the U.S. before the age of 16, and if you've lived here continuously since at least June 15th of 2000 until the present time, and if you're not over age 31 as of the date of this announcement, June 15th, 2012, and you don't already have some other lawful status, and you're currently in school or have graduated from school or gotten your GED, and you don't have any disqualifying criminal convictions, then we're going to allow you to remain here in what's called deferred action status, which is basically a quasi-legal status. It's not really legal status. It's just basically a prosecutorial discretion decision by the government to say, we're not going to deport you if we encounter you because you have this quasi-legal status, and we're going to give you a work permit valid for 2 years. With that work permit, you can apply for a Social Security card, you can apply for a license, which is just huge for a lot of these young people. All of their peers are getting their licenses, and they can't get a job and stuff like that. So deferred action allows them to finally get some sort of recognition that they can be here lawfully with authorization, and it really has been so exciting to work with these young people. You know, when they come in, we have to make sure that they're in school, so we see their school transcripts, and, you know, we have these young people who are getting straight A's and taking Japanese, and, you know, just really inspirational stories of people that we would want to remain in this country. And they're not all star students either, but, you know, really these people have grown up here, and they only know the United States as home. So deferred action has really been an excellent thing, and the response has been huge. At our first community workshop that we gave last summer, we had over 600 people come, and we had a line out the door when we got there at 7 in the morning, and someone had come at 10 at night, the night before, to be first in line. So it's just been the first glimmer of hope for so many young people that they're going to be able to get legal status in the country. And we hope that this will sort of be a springboard for more comprehensive immigration reform so that their parents can also not live in fear of being removed and can participate more fully in our communities. I believe.
Dreamers, are these
Yeah.
also the anchor babies?
Are these also? No, I think what's meant when people say anchor babies, I think what particularly politicians are meaning by that is U.S. citizen children who are born here. There's a misconception that if you have, if you have a baby here, that baby will be a citizen, but there's a misconception that somehow gives that parent some rights to be here legally. It's really not easy. You know, as I talked about, you can't even cancel your deportation unless you also have 10 years here, and your baby would have to be quite sick to be able to anchor you here in the U.S., you know, to be able to stay here. And also U.S. citizen children have to be 21 before they can even apply for their parents. So there's not much of an anchor there. I mean, it's not easy, even if you have children in this country. Yeah. I think that's the end of my prepared presentation. One thing about the deferred action is you need to be at least 15 to be able to apply. So we have applicants who haven't yet turned 15, but that we'll probably be seeing soon. So between the ages of 15 and 31 are the people who qualify for that.
Well, and Selena, if you could comment on our problem with Zoe this month. You'll recall that Zoe is getting on with her life and has been volunteering at the Hope Springs True Kitchen and Women's Shelter, and she met Dory from Bahrain. And Dory has overstayed her student visa, and she's afraid to go back to Bahrain because she had participated in the protests that took place there during the Arab Spring. Zoe has become friends with Dory. Zoe knows that Dory is here illegally, Zoe would be happy to have Dory take up and sleep on the couch since Smelly Melvin is no longer around. He went out when Herman went out the door. And Zoe is also concerned because Dory has a former boyfriend nicknamed the Hulk who dealt with heavy drugs. And the Hulk happens to be also stalking Dory. So with that fact pattern, what kind of advice would you have for Zoe?
Well,
Zoe's called again. You know,
yeah.
she's calling every month. We're getting tired of her.
I would say Zoe should have Dory look into the possibility of applying for asylum. You know, we don't know if the reason that she left Bahrain was because of any persecution that was going on. She came on a student visa, but maybe it was just handy to come on a student visa because she was being harassed or threatened in her home country because of her political activities. So if she had faced persecution based on her political opinion in Bahrain, or if she has a well-founded fear that she will be persecuted, then she may want to apply for asylum. And in that case, the first referral that I would make for an asylum case is the Advocates for Human Rights.
Right, and I'm glad that you raised that. Everyone, we're good on our training materials, but we're not perfect. So what I'd like you to do is to go to page 7 of your training materials. And up above where you see we refer to St. Cloud and Wilmer for legal aid, I'd like you to write the number 5 there, and I'd like you to write in the Advocates of Human Rights, Advocates for Human Rights.
Right. And they're actually on this slide as well. There we go.
If you could write in
So-
that number, 612-341-9845. That was our mistake in not getting it into the training materials. That Call for Justice's mistake. So write that in, and then when we post the training material on the website, we will have corrected that. Okay?
Yep, and they do only asylum. They work with a lot of volunteer attorneys, but they would be happy to evaluate her case and see if she has a viable case. And then, so it's not exactly clear everything that's going on with the Hulk.
Right.
In Dory's situation, sounds like kind of a dangerous character. He's been stalking her, and so it may behoove her to get an order for protection if she feels that she's in danger from him. As of yet, I don't see any immigration relief there that she qualifies for yet. But you know, if she gets an order for protection and he then violates it, she's U visa eligible if she cooperates with the police and making a report and giving them information. So that might be an option there. Yeah, I think it's certainly always a good idea to refer Dory, as she now is out of status, to an immigration attorney to evaluate her whole case. Who knows if maybe there's something else in her fact pattern that we don't know about that she could qualify for.
Okay, does anyone have any, thank you, Selena. Does anyone have any questions for Selena?
Yeah.
I had touched on sponsors. We've
Oh,
gotten
yeah.
many calls about individuals that have had sponsors and have left them. They haven't really, been there to fill the position that they're supposed to, and they're at a loss of what they can do and what their rights are.
So I think that brings up a good point that we sort of glossed over in this very, overview type training. But when you're applying for a family member, that's a great question. I'm just going to give the whole intro and then I'll touch on that. When you're applying for a family member, like say that you're a citizen and you want to bring your spouse, and so that your spouse can become a resident, one of the requirements of your application for your spouse is showing that you're going to be able to support them when they come here, and then that they're not going to be a public charge, as they call it, that they're not going to, have to request welfare right away or something like that. So what they require is for that petitioning family member to file what's called an affidavit of support. And that's basically showing that I, as the petitioner in this case, make enough money for my family size so that I'll be able to provide for my spouse. She won't have to request public assistance. which I think is weird because the law doesn't allow people to apply for public assistance for so many years anyway. But anyway, they make them show that they're going to be able to financially support them here. Say that that petitioner doesn't make enough money. Then they can get a co-sponsor. They can get a friend or a family member, someone who's at least a resident or a citizen to say, okay, I will be an additional sponsor for this person. I make this much, which is enough for my family size plus one more person according to the federal poverty guidelines that you use. So I'll be a sponsor too. So that's why people have sponsors. In a visitor visa context, sometimes before they'll give someone a visa to come and visit here, they'll also say, we want to know that someone's going to provide you lodging and meals and financial support so that you won't work during your visit. Now, those aren't really enforceable affidavits of support in those cases. But in a family-based case, if the person you're talking to is a permanent resident, I don't know, maybe you didn't get into that or
No, the
not.
majority of the calls we've had dealing with sponsors have been someone that was not a relative of the individual.
Calling on their behalf saying this person's suffering financially, their
The
husband.
opposite, the person
Oh.
saying that my sponsor is not,
Right, so
individual.
like, and when they say my sponsor, do they say who it was?
They didn't say necessarily who the person was, but they did say there was not a family member.
Oh, so it must be a co-sponsor in that case. And so the family member isn't helping out enough, I guess. And then the co-sponsor isn't helping them out too. Well, the law says that the affidavit of support is an enforceable contract that they can sue that person on. So if they can find an attorney and have the means to pay an attorney to bring that person to court, then that might be an option. It may be that that co-sponsor doesn't now have the means to continue providing support, or it may just be that they don't want to do it. I don't know.
It'd be hard though, because aren't they not legally here or able to work? The individual themselves that has the sponsor?
If they've been sponsored, it usually means that they have their green card now.
Oh, okay, okay.
Yeah, so that was a prerequisite for them getting their green card, was showing that they have a sponsor. Yeah.
Thank
Are you
you.
familiar with the citizenship test being like $1,500? Is that the going rate, or, because I had somebody call yesterday for looking for assistance, to pay for the test, and I had heard that it was like upwards of $1,000 they were asking for, and I'm just like, we don't have agencies that do that, but
Yeah.
are you familiar with agencies that do help sometimes people pay for the cost, or is that kind of outside your?
Well, the application for citizenship is called the Form N-400, and the filing fee for the whole process, which includes the test, because they have to be interviewed on their application, and then at that same interview they'll do the test as well.
Okay.
But the filing fee for that application is $680.
Okay.
It's not more than that. So I don't know if maybe they were talking about the attorney's fees that they were getting charged. And
I don't know.
that could be, and there are attorneys, I was in private practice for a while, and it sounds a little bit high, but there are attorney's fees sometimes. But once you pay that fee, then that covers the costs for getting fingerprinted, having your interview, going through the process, and hopefully getting your citizenship. Our office does representation in citizenship cases. So we're a great referral for citizenship, as well as the other Minneapolis Legal Aid, SMERLs. We all do citizenship. So depending on where the person lives, that might be a good referral for them. And if the person is low income and can document that, then they can also qualify for a fee waiver so that they wouldn't even have to, pay that $680 filing fee.
Oh, well, that's
So,
good to know.
yep, and all of our nonprofit offices offer representation free of charge.
Okay.
Yeah.
But you're at 187%, right?
Right, so yeah, we only take people who are below a certain income level for their family size. So if they're above that, they may need to go to a private attorney. I think, when I used to work in private practice, we charged $750 for our representation in the case, which included preparing the whole application, preparing them for their interview, and then going to the interview with them and representing them at their interview.
Okay.
So, yeah.
Any other
Question.
questions? Yeah.
Yeah.
Do you guys provide referrals if, say someone comes in at like 200% of poverty line? Do you provide referrals to those people, or?
Yeah, we do. And our our initial intake process is over the phone, and so that's the first thing we do is income screen, so that before we get too much farther, we can say, oh, sorry. But we will send out, we have a list of experienced immigration attorneys that we will send them, for sure. Yep.
And do you ever make exceptions at all? Or?
Very rarely, only if there's some compelling policy reason for doing it. Maybe it's a really, I don't know, super compelling situation. It hardly ever happens, though. I've heard about it in the past before my time, but really just to be fair to everyone, and because, you know, the only way that we're able to provide services is because we get donations and funding from government and charitable foundations. So, yeah.
Any other questions?
Well, I was just wondering if I could ask a question.
Sure.
You've had calls about sponsors. Any other types of calls that people get where you think maybe there's an immigration issue there? Yesterday, someone told me that she's gotten calls from a lot of domestic violence victims, and so she was happy to know that there were options.
Yeah, I'm happy
under the
to
law.
know about that. I had a caller that was concerned about, you know, her husband's abusiveness, and she just didn't want to go forward because she was, you know, so that's
Go forward
definitely-
with the police, you mean, or with?
Yeah, she just, you know, felt powerless in her situation, and I think to have known that I would have been able to empower her, you know.
Yeah, if people know that the law, that there's something that says that if you cooperate with police, you won't be deported. In fact, you'll be helped out and you'll get a legal status, you know, usually.
Right, but what you want her to do on that kind of a call is you want to, you know, you don't want to give her advice to talk to the police. You want to give her a referral to the Immigration Law Center.
Right.
Because it's, you know, there are always all kinds of wrinkles with everything, and you know, we would rather her talk to a lawyer before she talks to the police.
Oh, yeah, for sure. Yeah.
So,
Well, I don't know. I mean, sometimes that's what we say. Well, we do some safety checking, safety planning,
Right.
but that's kind of, yeah. But yeah, but I mean, we just tell people if you feel in danger, and maybe that isn't appropriate for your role. I'm not sure.
Yeah.
I don't know.
If you
I don't
feel
know
in
the
danger, call
parameters.
911.
Yeah.
Yeah, it wasn't like an immediate danger
Okay.
type of thing.
Okay.
More or less, he was just manipulating her in
Yeah.
you know, various
Well,
ways.
would it be appropriate for you to say, you know, I've learned that there sometimes are protections under the immigration law for victims of domestic violence.
Right. Yeah.
That might be worth talking to.
right, and
Yeah.
and I didn't interpret your question, Ann, being that there was immediate danger.
No, I know. Yeah.
I think that was me.
They've trained, these guys are exceedingly well trained, and they know that in those situations, when somebody's like immediately literally under the gun,
Yeah.
call 911.
Yeah, I
So-
can't even imagine the breadth of knowledge that you have to make all of the referrals on so many different topics. So to keep all of it in mind is incredible.
All right, well, listen, Selena, thank you very much. We're just
you.
about out of time, and I've got to squeeze a few things in. Will you help me in thanking Selena for a really nice... I want to thank everyone for completing the surveys that we sent out. They were extremely, extremely helpful, and they're helping guide how our program is going to go forward for the next year. So thank you very much for doing that. Secondly, I want to reinforce, you know, generally there's not going to be any way for you to triage somebody who's calling his immigration law question. I think the most important thing is to figure out, is there maybe an immigration issue here? And if there is, then our referrals need to be to the Immigration Law Center or to legal aid or something along that nature, along those lines. We do, however, in the materials at the bottom of page 6 and up to the top of page 7, talk about a brand new pro bono clinic that the Minnesota State Bar Association has put together on immigration law. And this is essentially for green card holders who want to go forward with getting their status to become naturalized or more permanent. And so if you have a green card holder and they're asking with that kind of question, I think that it's really safe to refer them to this clinic, and they can get some questions answered. And then if there's something more serious or more detailed, they can go on from there and maybe get a referral to the Immigration Law Center. But that would be a more targeted referral there. It is, of course, good to know about those various visas and good to know about the Deferred Action Program. I wanted to reinforce that our website continues to be present. We've been seeing the numbers, thanks Selena. We've been seeing the numbers go up on people that have been viewing our website. Please continue to send them to us. Remember, we have a number, not a lot, but we have a handful of for-profit organizations that you will not have in your database because of the way your database works, but you can be referring them to our website, to the button that says legal resources, right? Jillian? Resources for help. My colleague Jillian is always there telling me. And then they can scroll down and go to Alternative 211 referrals, and they'll be able to access those resources. We were thrilled on the survey to see how much that you're referring folks to the low bono programs in Hennepin County and Ramsey County. Please continue to do that. What you don't know is in the background is going to be the creation of a community law firm that will be focusing on low bono. So the extent to which those low bono referrals are being made, that helps justify the community law firm's existence as well. Once that is up, then we could be making low bono referrals right to that community law firm. But it's going to take a while before that's up. And last but not least, next month, we will have somebody from the Volunteer Lawyers Network here to talk simply about all the work that the VLN does. They're a very important community resource, and they are now starting to spread their work across the state, and where they're not just simply in the Twin Cities. So I think it's important that we just devote our time to one agency, get to know them better, and get to know what they're doing across the state. Okay? Anyone have any questions? I'm sorry I'm rushing, but it's the nature of the beast, and I'm really glad that you were asking Selena the questions that you did. We're never going to have somebody back again, at least not for a long time, on immigration, so it's really great to get your questions out. Anything else?
I sent some questions on immigration to before that, but I don't know what they are.
Okay, well, I'll tell you what. If they come to you, email us, and we'll get Selena to answer those questions for you.
Okay.
She's a legal liaison, so we have this great arrangement with her.
Okay.
Okay? Thank you, everyone. Have a great weekend.
Thank you.
Thank you.
All right, take care.